Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Marsha Amani Putri. My matric number is 1253498. So today I will be representing case review about MYRIAM versus Mohamed ARIF. So the agenda of today's presentation will start with the introduction, the overview, objective, issue of the case, fact of the case, continuing to the judgment, law applicable, discussion, lastly conclusion. So today I'm going to start today's presentation with the introduction. The case of MYRIAM versus Mohamed ARIF is basically about a child custody where the mother, after agreeing to the Sharia courts for giving her child custody to the father, later sought custody in the Civil High Court. This case also highlighted the question about the jurisdiction power between the Civil High Court and also the Sharia High Court disputes a matter involving a Muslim matter. So now, let's take a quick look to the overview of this case. The case focused for ensuring the children's welfare under the Guardianship of Infant Act 1961, using the powers of the Civil High Court, but still the court remains balanced with the Islamic custody rules with the principle that the child well-being must come first, meaning that the court will always prioritize the best interest of the children over a strict religious law. So now let's take a look to the objective of this case. The first objective is to examine whether the mother who has agreed upon the Sharia court's order of giving her child custody to a father is still entitled to apply the custody of the children. The second objective is to analyze whether the jurisdiction of the Civil High Court in deciding child matter under the Sharia court. And the third objective is to understand how is the power divided between the Civil High Court and also the Sharia court in case involving Muslim matter. Alright, now before we going further to the case, we have to know the issue of the case. In this slide, I have shown two issues. The first issue is whether the applicant still has the right custody of the children even after being agreed to the Sharia court for giving the child custody to the respondent. And the second issue is about whether the father's custody right under the Sharia law should take priority over the civil law while still focusing on the best interest of the children. Continue to the fact of the case to know what is actually happening here. The applicant, which is MYRIAM, and the respondent is Mohamed ARIF. They both get married but divorced after 10 years being together. During their marriage, they were blessed with two children. One of them is an 8-year-old girl and another is 3-year-old boy. Their divorce was through Qadi's court in Petaling Jaya, and divorce through a talak talik was granted. It said that the respondent will have the custody of their both children, but the applicant will have unlimited access to the child. What is happening after the divorce until she wanted to have the custody? After the divorce, the applicant frequently visited her children in the respondent house, but often found them absent. When present, the applicant noticed that their health and well-being was not being taken good care by the respondent, which is leading her to the custody. Which is leading her to seek custody of both children. Alright, now, after we know the facts of the case and what is actually happening, we continue to the judgment. The judge was made by Abdul Hamid Judge. The first one, he said that under the section 45 clause 6 of the Selangor Administration of Muslim Law enactment, it said nothing in this enactment shall contain affect the jurisdiction of any civil court, and in events any differences or conflict arising between the decision of court of Qadis Besar or Qadis and the decision of civil court acting within its jurisdiction, the decision of the civil court should prevail. It means that the applicant could apply despite the Qadi's consent order, and the civil court will have the jurisdiction to hear this case. The second judgment was made because of Section 5 and 11 of Guardianship of Infant Act 1961 was applied, as they do not have the conflict with or the contradict Muslim religious or in Malay custom. What is the third judgment? The third judgment is custody of the girl will be given to the respondent, while the custody of a boy will be given to the applicant until the boy reaches 7 or 8 years old. And last judgment was made because English and Muslim law agree that the child well-being is the most important factor here. So the court has the power to ignore this rule if it is better for both of their child. What is law applicable in this case? The first law that is applicable in this case is Section 45, Clause 6 of Selangor Administration of Muslim Enactment 2003. It explained that this enactment does not affect the authority of civil court. If there is a conflict between a decision that made by Qadis or Qadis order or a civil court, the civil court should override the decision. And the second law that applicable in this case was Section 5 and 11 of Guardianship of Infant Act 1961, Act 351. It explained that the court has the authority to determine the custody of the child if it is considered that such a good decision in the child's best interest, even if the child is Muslim. Before we close our presentation, I'm going to tell you about the discussion of this case. The first discussion is Islamic custody rule. Islamic law says that mother will lose the custody of her children, but the court decided whether to follow the rule or make an exception based on the child's best interest. And the second discussion is best interest of the child based on the Guardianship of Infant Act 1961. It said that the court focus on the child's well-being, make it priority over the religious, so that the judge has the power to ignore all the rules if it is what's better for the child. The conclusion of this case that we need to know is MYRIAM and MOHAMED ARIF case highlight that the custody of child disputes of a Muslim matter, the welfare of the child is being the most important things and important factor, and parents may seek a relief in the civil court under the Guardianship of Infant Act 1961. Even if the Sharia court's order exists, it shows that the civil jurisdiction coexisted with the Sharia court, methods to ensure that the best interests of the child are protected. Well, that's all for my presentation today. I hope I give the best presentation, and thank you for the cooperation. Assalamualaikum.